Good afternoon to everyone at today's public hearing of Panel A of the Prosecutor Vetting Commission. My name is Christopher Lehman, chairperson of this panel, and I declare the session to be open. The Prosecutor Vetting Commission is established under Law Number 252 on the external evaluation of judges and prosecutors. Law Number 252 establishes that this commission will undertake an ethical and financial evaluation of prosecutors who are identified in Article 3, Paragraph 1 of that law as subjects of the evaluation. This three-member panel is constituted to conduct the evaluation pursuant to Article 15 of Law Number 252. This hearing is being conducted pursuant to the provisions of Article 16 of that law, as well as the Commission's rules of procedures for evaluations under Law Number 252. The subject of today's hearing is Ion Șlicari, the interim prosecutor in the Anti-Corruption Prosecutor's Office. Mr. Șlicari, welcome. I am joined by my colleagues today on this panel, Nadezhda Hriptievsky and Bernard Levine. The panel is also assisted by members of our Secretariat. This hearing is open to the public and to members of the media. The hearing will be conducted with interpretation in Romanian and English. I encourage everyone to help ensure accurate interpretation by speaking slowly and clearly. The proceedings are being recorded. The recordings of this public hearing will be available on the Commission's website within 3 days after the hearing. During this hearing, one or more members of the panel will ask questions to you. Please answer them truthfully and completely. Your explanations are important to us in verifying your compliance with the criteria for ethical and financial integrity. In formulating our questions, we'll take into account your privacy and, where required and possible, privacy of family members and close persons. To that end, we will leave out unnecessary details relating to ID numbers, bank account numbers, specific addresses for real estate, and the like. And for the protection of your privacy, we would encourage you to do the same. You'll also be given an opportunity to make a closing statement to the panel at the end of the hearing. Let me start by briefly reviewing the evaluation process for this subject. The Commission initiated its evaluation on the 24th of May, 2024, by notifying the subject by email and asking him to complete and return an ethics questionnaire and a financial declaration form as required under Law 252. The subject returned the completed questionnaire and declaration on the 10th of June, 2024. As part of the evaluation of the subject and as part of the evaluation of his ethical and financial integrity, the Commission also obtains information from many other sources. These include the National Integrity Authority, the State Fiscal Service, the General Inspector of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains from these sources for relevance and reliability. The Commission sent you 3 rounds of questions. Those were on the 7th of April, 2026, the 22nd of May of 2026, and the 6th of July of 2026, and you responded to all of those. On August 14th, the panel notified the subject of today's hearing and further advised the subject that the panel, after the analysis of the accumulated information, did have certain doubts to discuss with you. Those doubts were detailed in an annex to the hearing notice, which was sent to you. On the 16th of August, you requested that the hearing be conducted in closed session. This request was partially accepted by the panel as detailed in our decision of the 20th of August of 2026. Therefore, at the appropriate points in the hearing, following the parameters set in that panel decision, we will proceed with questioning in closed session, and I will announce that at the relevant points of the hearing. We will begin, however, in a public session. Mr. Șlicari, again, I thank you for appearing today. I'll begin with two short questions that we ask of all subjects, and I'll ask you to respond in a complete and truthful manner. My first question is simply whether you wish to make any additions or corrections to information or to answers that you have provided up until now to the commission.
Dear Chairperson, thank you for this question. I support everything that I declared during the rounds of questions, everything that I annexed, all the documents that I annexed, and I also request for the panel to also take into consideration the written position with the annexes that were sent on 22nd of August this year, when I received the hearing notice. I sent you this document. Please take it into consideration.
Yes, we have those, and they will be taken into consideration. Second, I just want to clarify the answers to the ethics questionnaire and the declarations that you returned back on the 10th of June, 2024. Are those accurate as of today?
Yes, they are valid up until this day.
Okay. I'm switching some documents here. Give me a second. All right. Mr. Șlicari, I would like to begin our questioning with issues surrounding the purchase or acquisition of a Toyota Avensis with the manufacturer's year of 2008. You first took physical possession of that car on March 14th, 2018. Is that the correct date?
Yes, correct. I came into possession of this car on 14th of March 2018.
Okay, and I understand that you were granted a power of attorney over the vehicle on that date. Is that correct from the prior owner?
Yes, correct. On that date, 14th of March 2018, I received a power of attorney from the owner, valid for 1 year. The power of attorney was meant to conclude legal agreements, contracts, sale, purchase agreements on behalf of my father, who was back then abroad.
And did you retain a copy of the power of attorney?
As I've mentioned in the rounds of questions, I did not keep a copy of the power of attorney because in January 2019, I became the owner of this vehicle, and in line with the rules of the Public Services Agency, that power of attorney is kept with the Public Services Agency. Subsequently, I tried to acquire this power of attorney, or at least a copy, but it was not possible because in line with the regulations of the Public Services Agency, the documents are kept for no longer than 6 years.
Okay. And turning to the events of March 14th, 2018, who paid for the car on that date? How was the seller paid for the car?
This vehicle was paid for previously, prior to this date, prior to 14th of March 2018, as I've declared in the rounds of questions, and according to the own responsibility declaration or statement, this car was paid for in cash by my father. The money was sent to the daughter of the seller that owned and used this car directly back then.
And how much, I'm sorry, I didn't mean to interrupt you. Please go ahead.
Subsequently, on the 14th of March 2018, when I was empowered by the seller, when I had this power of attorney, I did not pay any price, any amount for this vehicle because it was paid for prior to this date by my father. And on the date of this legal document that was concluded, I did not even know about the price of this vehicle. I never knew about the price for this vehicle until I received concrete questions from the Commission on the price for purchasing this vehicle. I learned about the amount from the daughter of the seller and my mother. Sorry, please come closer to the mic, speak closer into the mic and speak louder, if you may. So on 14th of March 2018, I reiterate, I did not pay any money for this vehicle. I never paid from my money for this vehicle. I only exercised my right of representation. The seller empowered me by a power of attorney for this vehicle to be registered on the name of my father. So my father negotiated with the seller of this vehicle on the price and on all the other aspects.
So from the period of March 14th, though, you had possession of the car.
Yes, exactly, starting 14th of March.
Yeah, and was that your primary means of transportation from that date forward?
As I've answered previously in the rounds of questions, I do not deny that I used this vehicle, considering that my father was abroad for the majority of the year. He was in Germany, working in Germany. And because he was not in the country, I was using, when needed, this vehicle. But I was not using exclusively this vehicle because I didn't need to. I was not married back then. I had a public position in a state institution. I was a civil servant. The institution was close to my home, and I walked every day or I used public transportation. But yes, starting on 14th of March, this vehicle was used by me once the power of attorney on my behalf was signed.
And so it was only in January of 2019 that you used the power of attorney to register the ownership of the vehicle with the Public Service Agency. Is that correct?
Yes, exactly. This power of attorney, well, this was the purpose of the power of attorney. The seller gave me power to represent his interests so that ownership rights can be passed to my father. In summer or spring 2018, my father came back to Moldova, but for different reasons, he was not able to sign a power of attorney for this vehicle, and he left abroad once again. And in January 2019...
I need to correct you there because the power of attorney that you received was in the winter, not in the spring. It was on the 14th of March, 2018. So you previously told us that you received the power of attorney on March 14th, 2018. I just want to make sure that these timelines are correct.
Yes, correct, dear Chairperson. It was issued on 14th of March 2018, and it was valid for 1 year. So, starting on 15th of March 2019, I would no longer be able to use this power of attorney. Can I continue? So,
no, I think you mean you're confusing the dates, and that's going to be a problem. I think you meant you received a power of attorney on March 2014, March 14th, 2018, that was good until March 14th, 2019. Is that what you're trying to say?
Yes, this is what I'm trying to say.
All right. So you took the power of attorney, which is made out in your name, and on January 26th of 2019, you used that power of attorney to register the vehicle, signing both in the capacity of the buyer and the seller, correct?
Yes, exactly. This is how it happened. In January, I used this power of attorney to sign the ownership right, to pass it from the former seller to me. And it happened on the request of my father, who told me that he would not be able to go back to the country until this power of attorney is valid. And the seller was insisting for the ownership rights on this vehicle be transferred within a year, within 1 year. The power of attorney can be issued for 3 years in other cases, but in this case, that was the meaning behind this power of attorney. This is why we decided to have it for 1 year.
Yeah, and the power of attorney does not reflect your father's name, does it? It reflects only your name.
It couldn't include the name of my father.
My question was, I'm not asking a hypothetical question of what it could or couldn't have. I'm asking whose name was on the power of attorney. It was your name, wasn't it?
Yes, exactly. It was my name on the power of attorney.
Thank you.
We couldn't have another name on that power of attorney.
I'm sorry?
We couldn't have another name on the power of attorney. Of course, it was my name.
And in the contract that was completed by you, the sales price for the Toyota Avensis is listed as 20,000 lei, correct?
Exactly. In that contract from the Public Services Agency, the price is 20,000 lei.
But that's a form contract, and you knew that was not the price, correct?
At that stage, on the date of concluding the sale purchase agreement, I did not know the exact price for this vehicle. I learned subsequently this year about the price. And second of all, at that stage, as I've explained to the Commission in the first and second rounds of questions, I did not pay attention at the price indicated at the Public Services Agency, indicated by the seller, 20,000 lei. I did not communicate that price. It was not me. Maybe this is how things worked back then. There was a template form, and they would include price such as 10,000 lei or 20,000 lei. I did not communicate this price, and it does not reflect the real price paid by my father prior to this agreement. This price was communicated to the Commission in May this year.
But you obviously knew that the car was worth more than 20,000 lei when you entered this contract, didn't you?
Honestly, I did not pay particular attention to this contract back then, but also to the fact if it reflects the price that was truly paid by my father, because as I said, I did not know what was the price of that vehicle. if I knew it, and maybe if the Public Services Agency employee would have insisted to reflect the real price, I would have reflected it if I knew it back then.
But you also acknowledged to us that you were careless in the way you completed that contract, weren't you?
Sorry, you were? I couldn't hear you very well.
Careless. Careless. You sent us a statement yesterday where you, or earlier this week, where you acknowledged the carelessness that you displayed at the time of completing the contract that was submitted to the PSA.
Well, from the practice that I had with registration of vehicles, this is not a very official procedure, it's a rather technical one. On the standardized contract templates issued by PSA, they are just filled out and signed and printed and signed. No communication about it. Moreover, if I had at that time the dexterity and the attention that I had to detail that I have now as a prosecutor, because as I told you back then, I was not a prosecutor. If I had the experience I had to have today, I would have paid more attention. So in the circumstances that I mentioned, I did not pay due attention, especially with respect to the price of the car in that contract, the 20,000 lei. I have never paid attention to that amount because there were no questions about the content of that contract and the effects of that legal document. I started to pay attention to the content of legal documents when Commission asked how did I got this vehicle into possession.
So we're left with a situation where you completed a form contract that did not have the price of the vehicle. There's no evidence that you have of the price of the vehicle, and yet now you want us to accept a value different from what's in the contract.
I just want to add that that contract was not filled out by me. It is a standardized...
How can you say the contract was not filled out by you? You signed the contract, you had the power of attorney to do so, and you acted in the capacity of buyer and seller. So you did, in fact, fill out the contract. Nobody else did it for you. Correct?
Correct, but the contract is filled out by the officer of a PSA, not by me. I only signed it. And the price of a vehicle mentioned there was not the one set by me. I only signed the contract and I did not pay attention. It was an omission.
No indication of the real value of the car. Does it?
At that stage, I couldn't even know the actual value of that vehicle because the price was paid beforehand by my father. It wasn't me who paid for it.
And so up until that time, were you the only person using this vehicle?
I wasn't the only one who was using that vehicle. I was only using it when needed, occasionally, when my father was abroad, because when he was coming back to the country, my father was using the car, and sometimes my brother was.
So when was your father in the country?
At the time when the power of attorney was drafted, he wasn't in the country. He came back in the spring, summer of 2018. He used that car. Subsequently, in the autumn of 2018, and then in 2019, in the period when he was in the country, when he was coming back home.
Do you recall arranging the insurance for this car?
After the power of attorney was signed on March 14, 2018 in my name, I did not have any other power of attorney. Sorry, no other insurance policy for this vehicle. In January 2019, when the ownership right was transferred in my name, I obtained an insurance policy for that vehicle. This vehicle was insured only through the third-party liability insurance, no other extra insurances like Casco.
And you were the primary covered beneficiary under that policy? The policy that was obtained in January 2019?
Yes, exactly, because I was, from a documentary point of view, I was the owner of a vehicle and the first person who is contracting the insurance, lists the people who are beneficiaries in a decreasing order, lists the people who are beneficiaries in case of a risk event happening.
And on the 30th of January 2019, it was also you who presented the vehicle for the annual mandatory technical review at the National Road Transport Agency, correct?
Yes. I was the one who brought that car for the technical inspection.
And you were the one that paid for that procedure as well as the annual vehicle use road tax, correct?
Physically, I paid for the technical review for the insurance and the road tax, but the money did not belong to me. It was my father's money. The procedure went as follows. I told my father
Well, the
that
question was who presented the vehicle and paid the road tax. You went to pay the road tax. Was somebody with you that then paid it, or did you provide the money for the road tax?
physically, I was the one who paid it.
And your father's name does not appear on any document of any kind related to this vehicle, does it?
Well, that's possible. I don't remember if I listed my father in the insurance policy, because at that time there were two options of purchasing that insurance policy: for a limited number of people or unlimited, 3 or more people. So the price was different. And I don't remember if I had that type of insurance policy where the number of beneficiaries was unlimited. So I don't remember if my father's name was reflected in the insurance policy.
Well, I can refresh your recollection that no secondary beneficiary other than yourself was included in that policy. I mean, that is in the documents. Does that refresh your recollection that you bought a policy without a secondary?
I don't remember exactly what was the type of policy that I purchased. Certainly, I am certain that the policy was in my name also.
I'm gonna, at this point, I want to check to see, especially since we're remote, if any of my colleagues on the panel want to jump in with further questions on the car.
Yes, I do.
Nadia?
Domnule Șlicari, am să
Mr. Șlicari, I will ask questions in Romanian. If possible, I would like us to go back. And could you please explain how did your father pay for this car and how much? You mentioned, if I understand correctly, that he paid for it to the daughter of a former owner. Could you please explain when, how, and how much? Yes, thank you for your question. I can certainly say that the price was paid by 14th of March 2018 when the power of attorney was drafted. I was contacted a few days before that by my father, who told me that he paid the money for a vehicle to Citizen X, owner of a vehicle. He did not tell me the amount or any other details related to the negotiation and so on. He just told me, he sent me the contact number of that person for me to call them and to agree, and that person was going to issue that power of attorney in my name. I presume, but as I said, my father is not alive anymore. I can only presume that the negotiation took place both on the territory of the Republic of Moldova and Germany, because that person, back then and now as well, is working in Germany. But these circumstances were not offered to me by the seller of the car either. So later on, from the daughter of the buyer, from the buyer, seller, yeah, exactly, seller. From them, I found out that the money was paid in the first months of 2018. Could you please explain? Back then, in March 2018, what were you doing? At that time, I was a consultant within the anti-corruption within the prosecutor's office for organized crime. You were a consultant, it means you were a subject of declaration. Yes, I was. When were you first appointed into a public office? In July 2017, I was appointed a consultant. And when your father asked you to go and obtain that power of attorney, didn't you think that you have a position given which you should understand things because you registered everything in your name? At that time, on March 14th, this document did not raise any questions for me about its legality or validity. I was fully trusting my father, who said he agreed with that person to purchase a vehicle from them. Moreover, this document, the power of attorney, was issued and authenticated by a notary who is providing services of public interest and is registered in a registry. I did not have any money to be participating in a classic sale and purchase process. So all of this did not raise questions in my head in relation to that vehicle because the power of attorney was legal. But your father, when he paid for that vehicle, didn't he sign any contract? Nothing? No receipt? I don't know because I was not part of the negotiation and the transfer of a vehicle, but from the statement of the seller's daughter and the statement of the seller, it doesn't follow that some receipt was signed. But how did he give them the money? Wired? Money was sent in cash to the daughter of a seller. That was the request of a seller. So my father gave the money to the daughter of a seller, 150 euros, that were checked in an exchange office or a bank. I don't, as the daughter. So I know it was cash. Transmitted where? In Germany? No, the money was transmitted in Chișinău municipality, in Telecentru sector of Chișinău, in the vicinity of the seller's daughter's workplace, because she was the one who received 4,300 euros that I knew about from what they said. It means that your father was in Moldova? It means so, because money was given physically in advance by my father. So when was the money given? In January, in February, in March, or maybe in 2017? I can't say with certainty because I don't know. But from what the seller's daughter said and the seller said, they are using the timeline of end of 2017, early 2018. Well, on request, do you think you could provide a copy of a passport of your father? Do you happen to have it, to still have it? All copies of all passport pages that I had have already been submitted to the Commission from the round one, so you don't have anything else? Well, I don't know if there are any, but I sent everything I had. Once more, chronologically, let's check if I understand correctly. So, your father transmitted the money, but did not draft any document, or at least you don't know if there was any document. Then he called you, you said, exactly, and asked you to go and get a power of attorney, exactly, in your name. And you, on 14th of March 2018, got the power of attorney. And since then, you have used the car and you never obtained any insurance? Well, starting 14th of March 2018, I did not conclude any insurance policy because the insurance was still valid. It was insurance issued in December 2016 and it was valid for a year. The practice here is not constant about when when the right of ownership is changing, they don't always rewrite the name of the beneficiary, but I did not get any insurance policy in 2018 for this car. Do you happen to know why your father decided to give the money in advance while the car for 1 or 2 or 3 months would be still in the possession of the seller? This fact became known to me later on, recently, from what the seller said, who signed a declaration on their own accountability. And they said that this duration, this term between giving the money and issuing the power of attorney in my name, lasted like that, so that the seller could find another car for his daughter. And my father did not have an urgent need for that car, given that at that time he was abroad. Secondly, in our family, there was one more vehicle which was registered in my name, but was being used exclusively by my brother. So there was no urgent need. And for this reason, as the seller told, I understood that with my father's permission, he was granted a longer time to find a vehicle for his daughter. And do you mean that 14th of March 2018, was it upon your father's insistence to buy it then, or was it the buyer, the seller, sorry? Why didn't you wait until your father came back? Because you said he came back in the spring of 2018. Well, my father insisted. He called me, he was abroad, and he told me that I had to contact the person to meet the person who happened to be the seller of a car, so that he would issue a power of attorney in my name, and later on that vehicle would be registered in my father's name. This was my father's request. I couldn't reject it, and I did not go into a lot of detail. Was your father friends with the seller? I can't answer. Maybe they were acquaintances from abroad, but since my father and I were coming from another district, this person comes from another district, it's unlikely that they knew each other, but I can't say for sure.
So the vehicle, even though you got a power of attorney on your name, was exclusively for your father. Well, my father purchased this vehicle for himself, considering that the other car was used mostly by my brother. The purpose was to purchase a car for his own use. Yes, considering that he has two sons, he didn't want to buy a car for one of you. Initially, no, but subsequently, in summer 2018, this vehicle that was registered on my name, the ownership right was on my name, was given to me to have a transaction to cover the payment for another vehicle. Could you please tell us once again how often you used the vehicle and for how long your father used this car in 2018, 2019? Who directly used the car? I can say that this car was used by my father for more than 3 months in 2018 and for 1 or 2 months in 2019. It's difficult to answer because I don't exactly remember the time during which my father was on the territory of the country of the Republic of Moldova, but when he was in the country, he used this car exclusively. And doesn't it seem strange to you? Let's say you would examine such documents. The power of attorney is in your name. The sale purchase contract is in your name, and the insurance that you got immediately after having the right of ownership is in your name, and you did not even indicate the number of the name of your father. There is no other beneficiary, and there is no objective indicator showing that it was your father's car. Do you agree? I do not agree. The right of ownership was in my name, but it doesn't mean that I paid that price and I behaved as a beneficial owner of this vehicle. If I wanted to buy that vehicle, I would have by using several payment mechanisms, loans, bank credits. At that stage, I did not need to purchase a car, especially in the situation back then. I knew that the technical state of that car was not perfect. It was a choice made exclusively by my father. But you were an adult, you were not a student, you were not 18. It's difficult to understand how all the documents are in your name and you have no idea how much it was and why and what happened. There's no indicator showing that this car was purchased by your father from his money and not from your money. I couldn't have paid for this vehicle back then because I did not have the financial means, objectively speaking, for this. How could I pay for a car, the money for which I did not have? If I wanted, I would have done it classically by signing a sale purchase agreement from an auto dealer. But at that stage, it was the desire of my father, a well-founded legal desire to purchase a car, and that I don't believe I violated some legal provisions. You previously also mentioned that you learned for the first time about the real price of the car and thought about the real price of the car when in the second round of questions you were asked about this, correct? Yes. Do you maintain this answer? Yes, I stand by this answer. In the second round of questions, at the end of 2025 or at the beginning of 2026, I don't remember, but you completed a declaration in 2024 and you indicated a price of 20,000 lei for this vehicle. Could you please explain? I confirm in the last 5-year declaration and in the ethics questionnaire, I indicated the amount of 20,000 lei because at that stage, I did not know about a different price for this car, and I could have indicated another price than from the price that I had in a document in my possession, and I did because I was preparing information from public and private institutions. Subsequently, I found out that this vehicle was worth more, 4,300 euros, and the daughter of the seller communicated me this amount because she received this money from my father, but also I learned about this amount when I talked to my mother and we talked about the financial state of the family. If I knew about this amount, I would have indicated the real amount paid by my father. Yes, but Mr. Ion, you changed this car in 2019 for another one, and in 2024, when you filled in declaration and stated that it was 20,000 lei, didn't it raise questions? Didn't you think that you included some false information in an official document? Because it was a request to indicate correct amounts. We did not request to indicate a price in line with some documents, but a real price. After only 2 years, you realized what was the real price for that car? Well, when filling in that 5-year declaration, as I've mentioned already, I indicated the value, the amount that was in an official document. But subsequently, I found out what was the real price, and in the first or second round of questions, I communicated the price and I annexed own responsibility statement from the seller's daughter. Thank you. I have no other questions.
I have no further questions.
Thank you, Nadia. Bernard,
Yes.
I'm going to go on unless you have any questions at this point.
Yes, I have just only one question.
Sure.
Can you hear me? Yeah.
Yep.
Good afternoon, Mr. Șlicari. I just one question. Given all the information we already discussed together with my colleagues, it appears that all the documents concerning this car were on your name. No document was on the name of your father. My only question is, do you understand that we may see the situation as following? You constantly acted like the owner of this vehicle from the purchase of the vehicle till the sale of the vehicle. So my question is, do you understand that we may consider you as the only owner, because the only evidence you mentioned concerning your father is your statement, nothing else? Thank you.
Thank you for your question. I perfectly understand the suggestion of the panel, and considering the documents that were presented by myself, I believe that this perception according to which I was a beneficial owner and owner of that asset starting on 14th of March 2018, is counterpointed by the seller's statement. The seller's statement is a counter-argument. Only the seller can state on the reality that happened, and namely who carried out the negotiations, who was the beneficial owner, and most importantly, who paid the price and what was the full price for this car in question. Also, the fact that my father was the beneficial owner of that vehicle is the statement of the seller's daughter, who directly participated in the transaction and received the money from my father, but also the declarations and statements from my mother also confirm that my father was the one who purchased this car, and this money was used from the income of my father and mother, from their family. I don't believe that these legal documents, namely sale purchase agreement, power of attorney, and the documents related to the use of the vehicle, despite not showing that the car was used by my father, mean that this car belonged to me. If I wanted to purchase that vehicle, I could have done so openly by using loans from my relatives or banking loans, but also from non-banking institutions. I used this vehicle and I was just an intermediary between my father and the seller.
Thank you. We're left with a situation where all of the documents show that you are the legal owner of the car. You used the car, yet you dispute you're the owner. I'll move on with the questions. You ultimately sold this car 6 months later on July 16th, 2019. Isn't that right?
Yes, exactly. But to provide some concrete information, it was not a classical selling. It was exchanged as a part for the selling price of a new car. So it was part of the full price of another new car.
And that was a transaction that occurred at a called Auto Plaza, correct?
Yes, exactly. I confirm.
Yeah. Okay. So there is a sales purchase contract from the 16th of July, 2019, indicating that you bought at that point, and let me make sure I get the car type of car correctly. It was I don't have the make. The car that you traded in the Toyota Avensis, I believe, for a Toyota Aura. I just want to make, there's so many Toyotas, I want to make sure I have the cars described correctly. Can you clarify that? The car that you sold was the Toyota Avensis. What is the make of the car that you purchased on on July 16th, 2019?
I confirm that in July 2019, I exchanged the Toyota Avensis for a newer one Toyota Auris, manufacture year 2016, if I'm not wrong.
Okay. And just to clarify the nature of that transaction, the total price for the new Toyota Auris is 249,000 lei. Do you confirm that?
Yes, I confirm this price, considering that it is in line with the price in the contract.
And the dealer at Auto Plaza appraised your trade-in car, the 2008 Toyota Avensis, at 123,744 lei, correct?
I confirm this is the amount equivalent to about 6,300 euros. This is the amount they appraised the vehicle. So Intelligent Auto appraised this at this price. Now they are called Auto Plaza. I confirm.
And so the 249,000 purchase price for the newer Toyota consisted of that trade-in value of 123,744 plus what you made up in additional lei, 125,268 lei that you gave to the dealer, correct?
Exactly. This is how it happened.
Okay. And the cash that you had came from a loan that you had obtained, I think in the amount of $7,518 US from Credit Rapid. Is that, do I have that correct?
Yes, exactly.
So the obvious question is how do you explain your alleged purchase price in 2018 of a Toyota Auris for only 4,300 euro, when 15 months later, a professional dealer, somebody who runs Auto Plaza, a whole dealership, values the car at approximately 6,300 euro. Most of the time, cars go down in value, not up in value. So how do you explain that to us? We're struggling with that. This is your opportunity to answer us.
This amount of 6,300 euros is the amount of the price for the car as an appraisal, following the appraisal by the auto dealer. And this appraisal is done based on several criteria: aesthetics, technical aspects, individual aspects related to the owner, kilometers, and things like that. Following some verifications and inspection of this vehicle, this company appraised this car at 6,300 euros, the price that you indicated. And if I look at this data, and considering that this car was purchased by my father for 4,300 euros, and subsequently, after 1.5 years, this price increased by 2,000 euros, well, I'd like to inform the panel, as I've indicated in the rounds of questions, and as deriving from the statement of my mother, and I can also confirm, between 2018 and 2019, my father made several investments in this vehicle. The engine, but also the body. And summer tires were bought as well. This was done in 2018. beginning of 2019, and it led to an increase of the price for this vehicle that was appraised, in my opinion, objectively by that dealer that is specialized in selling vehicles in Chișinău municipality.
Yet we have no information at all about such investments being made in 2018. There's no evidence of that.
I couldn't provide it during the round questions because at my parents' home, no receipts or invoices were kept in relation to the investment of any funds into the vehicle to ensure its maintenance. And when I asked my mother, she couldn't tell me which car service my father would be using to improve a vehicle. I couldn't find that out either, since my father, when using cars, he did not have one specific car workshop that he would always go to when fixing technical issues of a vehicle. I know that previously my father had in his telephone some pictures related to the repairs of the vehicle, but I couldn't get a hold of that phone, respectively couldn't get a hold of a photo. So it's only my mother's statements and my statements, but there is no documentary support for these events, meaning specifically that my father invested in the vehicle.
You're aware that this is your burden when we're confronted with an absolutely extraordinary and implausible story that a car that you claim was purchased for $4,300 miraculously is worth $6,300 15 months later after you've used it for a year and a quarter. A professional auto plaza, dealer gives you 2,000 more euro for a car. You have nothing to show us to explain that increase in value, which no reasonable person would believe. You understand this burden is with you, don't you? I mean, you've come with a preposterous story, basically, and you have nothing at all to back up what is, to any reasonable observer, anyone who's ever bought a car, anyone who's ever sold a car, this is not plausible. That painting a car and doing some work on the engine increases the value of 2,000, a 30% increase in the claim value. I'm struggling. This is your opportunity to convince me otherwise, but you haven't done that.
I can reconfirm that these works took place, but since back then none of us knew that we would have to undergo the external evaluation. If I knew about that, I would have made sure that I get all the confirmation documents and pictures and fiscal documents, all of that related to the testing at the auto dealer or in the car workshops when my father was getting those services. But the situation is as it is. I did everything possible. I got my mother's statement. I tried to obtain documents from the dealer who communicated the true purchase price and assessment of evaluation price of the Toyota Avensis. I understand that the burden is on me, but based on objective reality, I did everything possible. I made all the efforts to get a hold of documents or records that were provided to the Commission immediately. I believe that this increase in the price was just because certain investments were made by my father, because without such investments in 2018-2019, that vehicle would have been assessed at a purchase price that I found out about this year, or maybe even at a lesser value. So, because first of all, when you buy a car and sell a car, the aesthetics matters, how the car looks like, and my father invested in it, and this contributed to the increase in the value of a car.
Chris, could I ask a question? A brief question?
Yeah, please.
Mr. Șlicari, to refresh my memory, to make sure, you were asked in the question rounds, and you said there were no improvements made to this vehicle. Now, but today, you declare something else. Could you please explain this contradiction? Thank you. Thank you for your question. It is not a contradiction. In round 2 or 3, I confirmed that my father made some investment in that vehicle that was based on my mother's declaration, who stated that my father did make some investments to remove some technical deficiencies to improve the aesthetics of the car. That's why I included it in my written position and answer that question, that my father made some investment. But what investment exactly and at what cost, that's a problem. I don't know. But I assure you that investment was made.
Anything else, Nadia?
No, not at this stage.
This is all troubling. Different stories at different points of the questions over the last several years. But at the end of the day, in 2019, you knew that the car had been valued at €6,300. Because that was part of your sales contract, and that's what you got for it, right?
Yes, I confirm that this vehicle in the summer of 2019 was evaluated by the company who sold me the new car, and it was evaluated for the amount of €6,300.
So I have to go back to a question Ms. Rytievsky asked earlier. If you knew that, why did you fill out a declaration to this commission with a misleading value in 2024? The statements you made to the commission in 2024 are outside your period of ethical evaluation, so we have no jurisdiction over your ethical behavior in 2024. But this is, I have to say, this is a very troubling situation. And it does affect the weight that credibility in your other answers. Do you want to address that?
Thank you. I mentioned that amount in the questionnaire for ethical and financial integrity for the last 5 years in 2024 with the amount of 20,000 lei, given the legal rationale that that was the price mentioned in the sale and purchase contract of January 2019 that was registered with PSA. I couldn't include another reference because this would have generated some doubts about my objectivity and correctness. This is a fact that, in my opinion, proves my openness to the Commission, that I mentioned the price that I had, and the price that was written in an official document issued by the PSA. I did not try to hide the value of that good. I did not try to to hide this vehicle that is somehow qualified as my property. In the subsequent question rounds, I established the actual value of that vehicle that was paid by my father, and I provided the commission with all of the documents and records. I mean, the declarations from the seller, from the seller's daughter, and from my mother, which are related to that fact. So I was transparent from the beginning with the commission. If I knew the sale price between my father and the seller, I would have stated it, but at that time I did not know it.
All right. Before I move on, I want to check again with my colleagues if they have any additional questions on the transactions in 2018 and 2019.
No.
All right. Okay. At this point, I'll turn to 2022. And at this point, I note that we will go into a closed session. Back on the public session, Mr. Șlicari, at this point, we'll move to some questions regarding purchase of 2 cars in 2022, a Toyota Corolla, third Toyota, and a Volvo. With regard to the first car, it's a Toyota Corolla, manufacturing year 2016. I understand it was acquired on 15 February from a third party. There was a sales purchase contract of the same date, and that was submitted by you in your answers to the commission. How did you find out that this car was available for sale?
Thank you for your question. In winter of 2022, to be more specific, in February, I did not have means of transportation. I did not have a car, but it was strictly necessary for my family and I to have a car, especially considering the position that I held.
So it's actually I asked you how you became aware of it, not why you needed it. So if we could stick to answering the question, it would be helpful.
This vehicle was identified by myself on the internet. It was a post on Facebook or Instagram or on another app. There was an announcement according to which it was for sale.
And where did you go to view the car? And how did you decide to purchase it?
It was either during the day when I saw the ad or the next day I traveled to a neighborhood in Chișinău together with another person, one of my colleagues, when I saw the car. And I was interested in the price of the car, first and foremost. The price was quite lower compared to other cars during that period of time. We went to the place. First, we called the author of the ad. It was a person called Vasile. He had a contact number there. We called him. We went there during lunch at 12. We went to a place where he kept the car and where he was also living. We looked at the car, inspected it visually, so to say, and we talked in a trilateral discussion, my colleague, I, and the seller, who communicated us about the more details about the car. And in these circumstances, I decided that it was an attractive offer. The price was good, especially considering that I was looking for a car.
So the sales the purchase price of the car is specified in the sales purchase contract as 50,000 lei. Was that the real price for the car?
Yes, exactly. This is the real price paid by myself as a buyer to the seller, the name of whom I indicated in the rounds of questions. And I'd like to say that this price was a negotiated price. It was not the initial price established in the ad. In the ad, there was a different price.
Well, we asked because according to documents from the Customs Service, that car, the 2016 Toyota Corolla, was imported by the seller only 3 months before with a customs value of almost three times the sales contract price. In other words, with a customs value of 140,000 lei and an additional customs duty of 18,155 lei, which makes a total price that this seller paid 2 months earlier of 158,156 lei. How do you explain the discrepancy between the import price and the price you claim to have paid?
Thank you for your question. I'd like to provide some arguments. Well, the arguments were provided in the answers that I gave to the panel on 22nd of August. This car was introduced to the territory of Moldova, was imported in Moldova on 18th of November 2021 by the father-in-law of the seller. Let's call him the de jure owner, not the beneficial owner, 3 months prior to the sale purchase transaction between the seller and I.
The amount of 140,000 lei that is included in the customs declaration is not equal to the price that was paid for the car in the country from which it was imported, and it's not the actual price paid by me, because that amount does not reflect the commercial economic price of a vehicle. It's just a mechanism for evaluation for import purposes. These are some customs matters that have no economic or legal reflection on the value of how much was paid for that car in the country of origin and the price that is paid by me.
Yeah, but there's a vast difference between what you claim to have paid and the customs valuation and the additional duties that were paid. It's not a slight distance, it's an order of magnitude of 3 times what you claim to have paid. And there is no explanation that you've provided to actually answer that. You've given us a few receipts for repairs, but those do not explain the difference in the two valuations.
I understand your question, but I want to say that these references have nothing in common. The customs valuation is done for taxation purposes. So the customs value was established as 140,000 lei in order to establish the customs fee of 18-something thousand lei as declared in the customs declaration. And for comparison purposes, based on the materials provided to me, and I was included in the same declaration at the same day, 18th of November 2021, this person imported one more vehicle, the same manufacturer, but another configuration, and it was assessed to in the same amount, 140,000 lei, and the customs fee was exactly the same amount, 18-something thousand lei. This means that the customs value established by the customs officer does not reflect, and it's in itself, if we generally look at the customs value of products, this is a reference for the purpose of taxation, but it does not reflect its actual value. I don't know how much this vehicle was purchased for in Poland, because the seller told me that the car was imported from Poland. Was it 1,000 euros, 10,000 euros? From the moment of when the car was imported, November 18th to 15th of February, when I purchased it, there was some time in between. The value of 140,000 lei does not have any reference, doesn't have any connection with the negotiation that I had with the seller of the car, because from the beginning, the owner of that vehicle, because as I said, the actual owner of the car was not the one who imported, because the one who imported it was the father-in-law. So that they set a price of 65,000 lei for that vehicle, claiming the technical deficiencies of the car and the fact that for 3 months he couldn't sell it, and the investment that was required. And as a result of the negotiation, and a third party was present during that negotiation, we reached the final price of 50,000 lei. That is the actual price that was paid by me on the same day, and it was specified in the sale and purchase contract on the same day, 15th of February 2022.
Why did you become so careful about having the actual price in your sales contract when in the previous Toyota that you purchased for 20,000 lei, it was clearly a fictitious price? So, I mean, you admitted you were careless previously in the sales contracts that you enter. So I don't know why we're now required to take at face value this sales price contract of 50,000 when you admitted that one of the previous sales contracts that you entered into, you just grabbed a price because it was on a form and had no relationship to the negotiated price. So I don't see why we should treat your behavior in this case different from the previous situation. There's a credibility issue.
Thank you for your question. I will answer as follows. I want to highlight that the contract in January 2019, whereby I purchased the vehicle based on a power of attorney, the Toyota Avensis.
About the contract of 2018, March 14th, 2018. There's a contract, and then it was entered in January of 2019 with the 20,000 lei price.
I just wanted to explain that sales contract of January 2019 was not a fictitious contract. It was a perfectly valid contract. However,
okay,
I
the
mentioned
price in the contract was fictitious. Maybe the contract was real, but the price was fictitious. And you have called it careless, the price. So, you know, you can split hairs, but that's where we are with regard to the contract from 2019.
Eu nu mă refuz de acele declarații care le-am dat.
I am not denying any of the statements I made before, but for accuracy purposes, I just wanted to say that the contract in January 2019 wasn't fictitious. A fictitious contract means something different in civil legislation.
we're haggling over words here. I'm not claiming that either of these contracts was fictitious. I am concerned that both contract prices, that the contracts both contain fictitious prices. That's what we're trying to get at here, because we really have no explanation for the price, either 20,000 lei or 50,000 lei.
Da, am înțeles, domnul președinte.
I understand, Chairperson. May I explain? These are two different contracts about two different vehicles. The price for the advances, 20,000 lei. From the declaration, I already explained that it was an omission, carelessness from my side, and at that time I didn't actually know what was the actual purchase price for that vehicle. While about Toyota Corolla, I specified that the actual price was 50,000 lei, and it was correctly recorded in the sales contract concluded at the Public Services Agency on 15th of February 2022, the price of 50,000 lei. This is documentary confirmed. When the contract for the sale and purchase was concluded in January 2019 for that vehicle, I did not have the thoroughness, the dexterity that I had later on in 2022 when I was already a prosecutor delegated in the anti-corruption prosecutor's office. I had another vision, I had new knowledge, and I was much more cautious about all contracts that I entered in and my family members entered in, because I realized the consequences that may happen if the legal regime of declaration of assets and personal interests is violated, especially when contracts are concluded that do not reflect the objective reality. And for this reason, I was much more cautious, and the amount of 50,000 lei that was negotiated and paid to the seller reflected the objective reality, and that contract, that amount was recorded in the contract, and subsequently all documents related to that transaction of 15th of February 2022 were provided to an integrity inspector as part of a check of declaration of assets and personal interests. And if I'm not mistaken, it happened more than once. Moreover, this contract was subsequently submitted to the State Tax Service as a primary document, taken as grounds for registering that property in my name. After that, it was used in a trade-in procedure, changing one for another, and it was assessed at a price of 120,000 lei, and all these documents were provided to the State Tax Service.
All right. Oh, I'm sorry, continue.
The legality of that contract and other documents that followed from that legal act were checked by state authorities, and that proves my sincerity, objectivity, and transparency that I had towards state authorities in relation to that vehicle. I had no interest and no purpose at that time to purchase a vehicle in a poor condition at a high price and mention in the contract registered with PSA the amount of 50,000 lei, and then to invest in it and then to pay for capital gain. That would be a situation that's unfavorable to me when the panel, for instance, has doubts about the amount mentioned in the sale and purchase contract.
Mr. Șlicari, the answer you've given is completely circular. Yes, the sales purchase contract says 50,000, and then everything you assert is based on acceptance of 50,000 as being the actual number. That is the question. You talk about the ethical integrity evaluations at the NIA. Well, this is an ethical integrity evaluation. We have a sales contract. Yes, that I've seen. It says 50,000 lei in the contract. We know that in other contracts, that price did not reflect the actual sales price. So we continue to have some concerns about what the actual sales price here is. We know that the customs service evaluated the value of this car at more than 3 times the price that's in the contract. So that leads us to ask more questions. You told us that you spent 18,000 lei for repairs. You don't have any documentation of those repairs. So we are left continuing to doubt a sales price of 50,000 lei. Now, you're aware, or according to the NRTA, on the date of the vehicle's purchase, is the 15th of February 2022, it underwent a technical inspection. It was certified as roadworthy. So there is nothing that would have diminished the value from the customs value. And we haven't had an explanation for the difference between those two valuations. The simple fact that the amount of 50,000 lei is stated in the contract doesn't do anything to establish the valuation of the car. Now, you did not declare this car to the NIA, did you?
In the Declaration of Assets and Personal Interests for 2022, this vehicle was not included in the Declaration of Assets and Personal Interests under the Vehicles section, because this vehicle in 2022, well, I became the owner in February 22, and then 4th of June 2022, I stopped being the owner of it when I left it in the authorized parking in Chișinău under the trade-in contract or the exchange contract. So the same plausible explanation I provided during the review of the declarations of assets and personal interests done by NIA, under which section 4 I have to declare the vehicles that I own on the date of a declaration, and therefore I did not declare that vehicle because it wasn't my property anymore. It doesn't mean that I hid this good, because it was registered in my name. I paid to the tax authority the tax for capital gain in an amount of 4,200 lei. I had an insurance policy issued for that vehicle, and it could be easily checked through traffic surveillance cameras that I was a beneficiary of that property, but based on the law on declaration of assets and personal interests. When filling out that declaration, I consulted inspectors from the National Integrity Authority who, well, we discussed and we reached common grounds that this vehicle is not to be declared because it's not my property anymore. I purchased it and I sold it, and the money was reported as an income.
This is a very long question the answer to a simple question. You did not declare the car to the NIA, did you?
I did not declare it.
Okay, thank you. So let's move ahead. You sold the Toyota Corolla in June 2022, and I think you said you took it to the lot, I guess the dealer, where you could leave it until they actually completed the sale, correct?
Yes, exactly. That's exactly how it happened. This car was left at the parking lot.
So now we have a new valuation for the car. It was appraised at 120,000 lei, correct?
correct, yes. The dealer assessed this vehicle at the amount of 120,000 lei, the equivalent of 6,000 euros, because they were doing these assessments in euros.
So now we have two valuations of the car, both of which are substantially higher than the 50,000 lei that is in the previous contract. Can you explain why a professional auto dealer paid you 120,000 lei for a car that you alleged was acquired for 50,000 lei? It's only 7 months later that the car is appreciated by 140% in value.
Thank you for your question. I can explain it. Since I purchased this vehicle on February 14th at the price of 50,000 lei in a poor technical condition. All the technical deficiencies were described during the question rounds.
When you purchased it on the February 14th, you took it on February 15th. The next day, it underwent a technical inspection. It was certified as roadworthy. No visible damage to the car is seen in the photographs at the time of inspection. And it was not involved in any traffic accidents between the time of import and the time you purchased it. So we have no indication that there was a problem with this car.
Yes, indeed. I confirm that on February 15th, this vehicle went through a technical inspection where, as part of the procedures carried out by the National Transport Agency, they took two pictures of the vehicle. But these photos that ANTA provided to the panel are far from reflecting the technical and aesthetical condition of the car. The pictures prove just that the purpose of taking pictures as a procedure that is part of technical inspection is to prove the fact that the car is physically present at that technical inspection place. And the pictures do not reflect the technical condition of the car, because during this procedure, they just start the engine for a few seconds, they check the lights, and
Procedura. Puteți la subiect să explicați.
We know the procedure. Could you please explain it on topic? Speak on topic. Without explaining the another procedure, because we know it.
I'm just trying to explain what was the rationale why this vehicle was purchased at a price of 50,000 lei. I never claimed before the Commission that this vehicle was involved in any car accidents, traffic accidents on the territory of Moldova. So, from what the importer said, this car was involved in some accidents. I don't know about the circumstances, about the flooding in Poland. It was subjected to. And so the condition of the vehicle was known by the importer, who was the effective seller of this vehicle as well. And I provided my statements, the statements of my friend whom I went with during the first day to see the car, and I also submitted this information based on the statements of the acquaintances who helped me to conduct the repair works for this car. This car was improved. I invested 18,000 lei in it, and considering that starting in February we had a war on the border, there was steep decrease of the prices. Cars were being sold, but none were imported. So the price and the investments plus the economic situation led to this vehicle being appraised by the parking lot of the auto dealer to be appraised within this procedure of trade-in, and it reached the amount of 210,000 lei. I think it's an objective appraisal of the parking lot or of the dealer. There were no technical inspections done by the dealer. Only some people empowered to assess the vehicle from the company appraised the economic value of the car, and they indicated the amount or the price for this car, 120,000 lei and no more, considering the aesthetical, technical parameters and so on.
Well, what we have is a logical explanation of the price of the vehicle. Was imported with a value of about 140,000 lei plus in November of 2021. It was inspected. It was found to be roadworthy. You claim to have made some minor repairs of 18,000 lei. And then when you sold it 7 months later, you got 120,000 lei for it, which would reflect the normal depreciation of buying and selling a car. So presented with all of that information, we're supposed to set all and accept a 50,000 lei price and a 150% increase a few months later when you sold it again. You understand why we have serious doubts about this transaction, especially given the fact that in prior contracts for cars, you really were pretty careless, to use your own word, about the prices that were entered in the sales purchase contracts. That's why I have a doubt, a serious doubt. So can you help me alleviate that doubt? Because you haven't done it so far.
Yes, dear Chairperson, thank you. I want to say that there was one contract from 2019 regarding Toyota Avensis. And I reiterate once again, I was careless. It was not intentional with that price. Considering this particular car, now I agree with you. It raises questions with the Commission, considering that the value after 7 months increased from 50,000 lei to 120,000 lei. But everything that I've said are objective things that can be checked publicly, but also based on some documents. The prices for cars in the first half of 2022 increased significantly. Moreover, I never said that the investments of 18,000 lei were minor. The investments made in this car, they were minor. If I did these repairs with an official dealer, I would have paid double or triple for that. But I did this with some acquaintances, with spare parts that were not necessarily original, that were not authorized. Now they work legally, they pay taxes, but back then they provided me some support, some help, because I personally was not able to use this car. It would hit too much. So I explained all of this to the Commission already. Moreover, in my written position from 22nd of August this year, I annexed several pictures of this vehicle before it was imported from Poland, where you can see indeed that the bodywork paint was bad. It was rotten, and it shows that it was subjected to a flood. And these pictures were downloaded from a portal. And there's a full database, and there are data on the mileage and other circumstances for this vehicle. And it had a mileage of 155,000. Actually, not 155,000, but more than 200,000. So the mileage before the import was subjected to some changes before the car was imported to Moldova. So all these objective things show that this car was in a poor technical condition. I improved the condition of this car, not fully, because if I did, I would spend too much. I would have spent too much. And the real price was truly 50,000 lei. I didn't have the 140,000 claimed by the customs to purchase such a car. And I would have sold it for much more, for 200,000 if I paid for it 140,000. But it was purchased for 50,000, investments were made, and then it was exchanged for another one, and it was appraised at 120,000. And for this capital gain, I paid a tax. I paid a capital gain tax. Moreover, the tax service did not accept as evidence own responsibility statements from acquaintances that conducted the refurbishments and repair works. They requested receipts, bills, and I was not able to deduct this 18,000 that was invested in between March and April in 2022. I conducted some repair works on this vehicle back then. And considering the pictures that I presented, statements, the statement of the owner, the statements from third parties, a third party who went together with me to verify, to check this car, when I registered this car on my name, and even he was present when I gave the money, the 50,000. I intended to transfer the money on the bank account of the seller, but he refused. He said that he was tired, and he imported another car that night, also from Poland. But I'd like to go back to the amount established by the customs service, 140,000 lei. During that day, that importer imported another car of another model, other size, other characteristics. I don't know the year of manufacture. Maybe it's clear from the customs declaration, but they appraised it in the customs at the same amount, 140,000, considering the capacity of the engine and mileage. So this amount established with the customs service is a reference point that is used for the tax, for the customs duties and taxes that are to be paid by the importer. It is not in line with the real commercial value of the car, and it does not represent the amount that I paid.
It is in line with the real commercial value of the car because, in fact, an auto dealer paid you a similar amount, slightly less, 7 months later. So in fact, the customs duty is much more in line with the real value of the car than your purported contract price. I mean, you keep changing your story and changing the grounds, but it doesn't change the basic facts that are presented here. Car was imported with evaluation. There were a claimed 18,000 lei in repairs. It's sold 7 months later for a price that's slightly lower than the valuation by the customs service. That all makes sense. The 50,000 lei price does not make sense. You know, and I'm not, I feel like we're going around in circles because nothing you've said explains the 50,000 lei price. It's implausible that two separate dealers plus the customs people would all be so wildly off base, and only you were accurate as to the price being, you know, 2 or 3 times or more than 3 times less than the apparent value. But if you can answer that, go ahead. And I'm going to yield the floor to Ms. Fripetievsky in a minute, but please go ahead.
Dear Chairperson, I stand by my statements in line with the documents and receipts provided to the panel. And I firmly insist that the real price was 50,000 lei, the one indicated in the contract, and the subsequent price of 120,000 established by the dealer is the initial price plus the improvements brought to that car, and plus the economic situation back then, the steep increase in the prices for cars at national level.
Nadia, please go ahead.
Thank you, Chair. Domnule Șlicari.
Mr. Șlicari, let's recapitulate. You saw the materials and you mentioned yourself the owner of this car, who imported this car in November 2021, 3 months before selling it to you. This car was registered and appraised at 140,000 lei, and they paid customs duties of 18,000. So this seller sold you this car for 32,000 lei, if we use this logic. So it's a seller that has his main activity selling cars, as you've said. So you say that they will pay 18,000 lei in customs duties, and they don't say that this is a wrong amount to pay less, and they have a profit of 32,000 lei for such a car? Thank you for your question. Yes, indeed, these are the circumstances deriving from everything. I do not doubt that the customs inspector appraised this car at 140,000 lei, but I insist it does not reflect the commercial value of this vehicle. It's just a reference amount the customs inspector uses when doing their duties. Okay, about the price, how realistic it is for a car importer, for a car seller, to have a profit of 32,000 lei when selling a car. Is it realistic? It is. In the situation where this person, well, it's not a profit, it's just a selling price. Well, considering everything communicated by the seller and based on the statement submitted to the Commission, he was not able to sell this car for more than 3 months because of the technical condition of the car. If he kept it, maybe he would sell it for a lower amount, maybe for 20,000 lei then. If he invested in it, maybe he sold it for, he would sell it for more. Tell us how a professional who buys and sells cars accepted a price in the customs, paid 18,000 lei in customs duties, and you are a prosecutor. Well, you have nothing to do when it comes to buying and selling cars. You have nothing to do with that, and you invested 18,000, you paid 50,000, and you had a profit of 51,500. Do you think it's a real situation and a comparable situation? It is realistic. I was just lucky. I don't know if it's correct to say that I was lucky considering the situation in the region back then. But as I've said, at the beginning of February, back then, the prices for cars increased by a lot. And this can be verified. Okay, understood. Next question on the same topic. You said that in the annual declaration for 2022 that you submitted in March 2023, I suppose, you did not declare it because you did not have the car in your possession. But the declaration for 2021 that you submitted on 13th of March 2022, well, you already had in your possession this car. Why you did not declare it? I confirm in the declaration I submitted in March 2022, submitted for the tax year 2021, I did not indicate this vehicle, considering the interpretation of Article 4, Law 133 on declaration of assets and personal interests, and the same position I annexed to those from the National Integrity Authority. Mr. Șlicari, it means that you interpret the law as you please, because interpreting the law is one thing, but the text of the law says all assets in your possession. And several minutes prior to this, you said that in your declaration for 2022, you did not declare it because it was not in your possession. You did not declare it. But on 13th of March 2022, when you submitted the declaration, it was recently bought. You bought it 1 month prior to submitting that declaration. Why didn't you declare it? I agree, I did not declare this vehicle. Because of the same reasons, I interpreted the Article 4 from the law 133. What interpretation? On the assets that are declared, all the assets that are declared from the previous year. So these are assets from the previous year. And it's not only me interpreting the law in this manner, but also some colleagues do that. Well, in the declaration for 2022, you had to declare it that because it was an asset that you had in the previous tax period. Yes, I do not deny that I did not indicate it in the declaration of assets and interests for 2021. That includes other assets. It was an interpretation that I made during that period of time regarding this, and regarding this situation, I provided explanations to NIA. I did not keep it as a secret. I paid taxes for that, and I also got an insurance.
Hello?
No additional question.
Okay. Nadia, are you finished?
Yes, I am finished. I just said I have no more questions.
Mr. Șlicari, I do need to reference one other point. We had noted in the annex to the hearing notice at paragraph 38, up until now, we've been talking about this particular car, but I can't put aside the fact that when the Secretariat looked into this, there are 17 other offers in July 2026 for similar cars with sales price of 209,000 lei. Now, this is 4 years after you sold the car in question. Are we supposed to regard all valuations for this make and model of Toyota, which clearly even now has a value 4 times what you claim to have paid for it in 2022?
I do not deny the existence of these ads regarding the sale of such vehicles at the price that you mentioned. Well, these prices, they're probably real since they're published, but we are not talking about the prices that existed 4.5 years ago and the technical condition of that specific car that was found and purchased by me.
Well, the cars 4.5 years ago would have been higher. Cars depreciate. I mean, that is like, you know, a fact. Cars depreciate in value. So the valuations now are going to be lower than the valuations in 2022.
Yes, of course, but the technical condition of a vehicle matters a lot. Maybe the mileage matters not that much, but the technical condition matters. I bought the car at a very advantageous price related to its technical condition.
You've presented about the technical condition of this car that would lead to the drastic devaluation. We have we have 2 independent valuations that are substantially higher. We have pictures of the car in which it looks very good at the inspection in February of 2022. It was roadworthy, and beyond that, it's in very good shape. You don't have receipts. You claim 18,000 in repairs, for which you do not have receipts, but 18,000 lei in repairs would not explain this drastic devaluation of this price. So we're supposed to disregard all of the evidence presented. Is that where we end up in the final analysis?
Nu, domnule președinte,
No, Chairperson. I have just underscored that the totality of my evidence, they are more numerically, they are more objective than what the panel makes reference to. 2 pictures from ANTA that show pictures of the vehicle only from the front, not seeing the inside of the car, and other part of a car body, compared to the 8 to 10 pictures that I provided to the Commission that shows a poor condition of the vehicle. With respect to the alleged receipts that I should have submitted in order to prove the repairs of the vehicle, 2 receipts cannot have more evidentiary power than declarations of people who actually did the repairs of my vehicle. Those persons provided their mobile numbers. They were open to be questioned by the Secretariat or for information to be requested from them about that vehicle. Moreover, I have declarations from the seller of the car who has no connection with my work. We are not friends, we are not relatives, we have never had any relationship. For him, that vehicle is not different from any other vehicles that he had been importing for personal purposes or for the purpose of selling them on the territory of Moldova. And the most important is the declaration of a third party who accompanied me from the day when I found this ad until the date of registration of a car and giving the amount of 50,000 lei to the seller. The fact that a vehicle depreciates over time can be caused by various aspects, technical, economical aspects. But one thing is certain, I paid for this vehicle an objective price that is recognized by the seller, and he, in his declaration on own responsibility, he honestly explained that he couldn't sell this car for 3 months because of its technical condition. Because as every day went by, this car was more and more corroded. Unfortunately, I didn't keep any pictures of that because I did not know I was going to be subject to this evaluation. But I did my due diligence and I obtained these pictures that were made by companies that are from insurance companies in EU member states, which were included in this compendium of information from Car Vertical, where you can see the condition, the mileage, and the fact that until 2021 it had 2 accidents, so damage. It had damage. I had no interest to decrease the price, especially since that price is confirmed by declarations of all other persons that I mentioned. I paid tax. I did not avoid paying the capital gain tax. You know, if I paid a high price, given the investment, that I could have obtained a higher price on the 4th of June when I sold my car for trade-in. It could have been assessed for 200,000 lei. I would have been paying less for the Volvo car that I purchased. But I had the objective condition at that time that was justifying that price. Therefore, I believe that I was open, honest enough with the Commission regarding the price that was paid for that vehicle and all circumstances that contributed to the increase of this vehicle's price. I had no reason to understate the value of the car. Even at the price that is claimed by the Commission established in customs, 140,000 lei, which is far from its commercial price. These are 2 different things, 2 different institutions, commercial price and customs value.
Right. At this point, you're just repeating things you've said already. So unless you have anything new, I think we can draw this to a conclusion.
Well, Chairperson, I don't have anything additional, anything new to add to what I have already said.
Let me ask my colleagues if they have any other further questions at this point.
No.
All right. At this point, Mr. Șlicari, we give you the opportunity to make a closing statement to the panel.
Thank you, esteemed Chairperson, members of the panel. I would like to thank you for the time offered for the independent and impartial evaluation. Honestly, I thank you for the opportunity to express my position and to provide open, transparent explanations in line with the existing legal framework. In my opinion, this procedure is difficult, but it is strictly necessary in order to strengthen the position of citizens in relation to the justice sector activity and prosecutorial service activity particularly. I would like to thank my family, friends and colleagues who were by my side in this process and provided moral support to me. Thank you for your time and for the objective way of conducting this process.
Thank you for your participation at the evaluation today and throughout the entire evaluation process. The panel will now deliberate on this matter and the hearing is closed.